Hi, welcome to the webinar. My name is Alexandra Alvarado. I'm the Director of Marketing and Education at the American Apartment Owners Association. I am so happy to have you all with us today. We are going to be discussing the California Landlords Legal Survival Workshop. I named it that way because I feel like we are all trying to survive, and next year is going to have even more changes. We've already seen changes recently to some of the California laws, and I thought it'd be a good idea to bring Stephen back to the group to discuss what it is that's going to be coming up for next year, what has just happened, and sort of where that puts landlords. And I'm really excited because he is a partner at Fried and Williams, and he has a lot of experience, especially in the Bay Area, although a lot of this will apply to all of you in California. So if you're a landlord in California, this webinar is definitely for you. And just before we begin, and I hand it off to Steve, the presentation is going to be about 60 minutes, maybe a little less, and then we'll have some time for questions after. So, we often get a lot more questions than we can answer in one webinar. We will try to get to as many as possible. We may go over the hour mark, so I hope that you'll stick around. But if you don't, then we will have the recording sent to you tomorrow. So don't worry too much if you're not able to catch the whole thing. I will go ahead and pass this along to Steve. Steve, thank you so much for coming back and speaking to our group. We really appreciate it.
Thanks, Alexandra. Now, I recall that I first came on and giving talks for your organization. Gosh, it was probably in the summer of 2020 when we were really entrenched in the whole pandemic and the COVID moratoria and restrictions on landlord tenant laws. And I've given a few talks over the last year and a half or so. And so you've sort of seen how these things have unfolded and how it's evolved and how really it's a work in progress. And that's what my talk today is going to be. I really wanted to focus this on sort of where we are with the COVID laws and what are we able to do or not do right now as landlords and property owners. And I saw, Alexandra, you forwarded me a great list of questions. It looks like there's probably already about 30 or 40 people had sent some questions to you. And I will be focusing this on, like I said, the sort of the COVID laws and where we are with that. And the majority of the questions dealt specifically with that. So I feel confident that we're going to hit a lot of the answers to those questions today. And I'm really going to paint a broad overview. Like you mentioned, my offices are in the Bay Area. I do practice outside of the Bay Area and all throughout California. I just happen to be located in the Bay Area. But a lot of these laws will apply. In fact, they do apply throughout the entire state of California. It doesn't mean that there aren't local specific laws and things to be concerned about, but we'll touch on a lot of that. So let's go ahead and get started. And again, I thank you again for inviting me back to talk to your group here. So yay, the state eviction moratorium is over. Landlords can start evicting now for non-payment of rent, right? We can just jump right in and give your old 3-day notices and proceed when a tenant hasn't paid rent going forward or in the past. So we can celebrate, right? That's where we are these days, because as everyone read or heard, the moratorium, the state moratorium expired at the end of September. So we're free to now evict, right? Not so fast. Now, those of you who are who watch College Game Day on ESPN will be familiar with that term, not so fast. But here, not so fast. Don't rush to serve your 3-day notices and get your cases into court for non-payment of rent just yet. There's ongoing issues we need to discuss. So just sort of what are some of those ongoing concerns or issues? Well, there's local moratoria that you need to be concerned about or at least be aware of. There are rental assistance programs you also need to be aware of. And I did see a few of the questions were tailored or focused on the rental assistance programs. There's court restrictions and requirements as well to get your cases into court these days. And as part of that, there's also a waiting period before you can even get your case into into court these days as well. And all this pertains to a non-payment of rent eviction. So your typical 3-day notice to pay rent or quit that you were serving pre-pandemic may not be applicable. In fact, is not applicable right now. And I'll get into that, but I'm going to give a general broad overview here. So, first, there's the COVID-19 rental debt. And that is all unpaid rent that is accrued from March 1st, 2020 through September 30th, 2021. So we're talking a year and a half. Well, conceivably, you can evict for non-payment of that rent, or at least a portion of that rent. Here's the general outline. This is, sort of what the lay of the land has been over the last year approximately as to what you can do. Is you have to give a 15-day notice to pay the rent. You also have to provide the tenant with a tenant declaration of impact by COVID. And if the tenant returns that, it precludes you from proceeding with any type of a non-payment of rent eviction for rent that accrued during that period, again, March 1st, 2020 through September 30th, 2021, so long as the tenant pays at least 25% of that rent due. If the tenant didn't return the declaration, or more importantly, didn't pay that 25% of the rent that's due after having been given a proper 15-day notice, then conceivably you could potentially get your way into court with a non-payment of rent eviction. Again, there's a lot of red tape and other things to consider, and I'll talk about that in a moment. But in theory, you can potentially get into court for non-payment of rent for rent that accrued during this past period. If you've given that 15-day notice and the tenant has returned a declaration or hasn't returned a declaration, but has not paid at least 25% of the rent due. Okay. The other 75% you can never pursue. You cannot pursue that additional 75% through an eviction action. You can pursue it through a court, a general civil action for the rent debt, but you cannot pursue it through an eviction lawsuit. Only 25% of the rent that accrued during this period. So again, we're focusing on this past rental debt period. As another obstacle, there were informational notices that were required to have been given throughout the last year and a half. And if they were not given, then it precludes you from seeking that rental debt that predates the date that notice was supposed to have been given. It's a little confusing, but let's say a tenant owed, had unpaid rent in June of 2021. Okay, that clearly falls within this rent debt period. And you'd like to serve your 15-day notice, or you served a 15-day notice for that rent. Well, if you did not give your July 31st, 2021 informational notice, as you can see there, then you may be precluded from proceeding for that June rent. Or if you did not give your February 28th, 2021 notice, you may be precluded from proceeding for rent that was due before that date. So those are hard dates that if you did not give those forms, those informational forms, then you can't proceed with an eviction for that rent. So assuming you gave that July 31st notice, or by that date, that informational notice by that date, and the tenant's June of 2021 rent remains unpaid, you give your 15-day notice, tenant returns the declaration and fails to pay at least 25% of the rent that was due, you could conceivably get into court on a non-payment of rent eviction action for that rent. Now, as some of you may be aware, there's a 1-year statute on non-payment of rent eviction notices, meaning traditionally you cannot demand in a 3-day notice rent, or here a 15-day notice, for instance, rent that predates 1 year prior to the date of serving that notice. So you couldn't seek March 2020, for instance, under normal circumstances, because that's more than a year past. However, during this COVID rental debt period, that statute was told. So you could go back to March of 2020 and seek rent that was unpaid with that 15-day notice and with your declaration that's required. And if the tenant doesn't pay at least 25%, you could go into court with a non-payment of rent unlawful detainer action. It's a little confusing, but again, this whole time has been very confusing for landlords and property owners and landlord attorneys. The laws have changed practically on a daily basis at the local level, at the city level, at the county level, at the state level, at the federal level. There's all these different laws that we're having to contend with. But just keep in mind that the important part is that for this period, March 2020 through September 2021, you can only really seek 25% of the rent in a non-payment of rent eviction lawsuit. And the chances of even getting that these days, like I said, because of all the obstacles, is probably pretty slim. But let's talk about, so that was this real protected period for that year and a half. Well, as I mentioned, the moratorium ended September 30th. So well, what about October 1st? Well, certainly I can jump into court with a 3-day notice now if they don't pay rent for October or November or December of this year, right? Not, again, not so fast. You are entitled to 100% of the rent now. Remember, prior to October 1st, only 25% you could pursue in a non-payment of rent eviction action. Well, now you can pursue 100% of the unpaid rent beginning October 1st, all right? And this continues through March of 2022. However, a special, unique 3-day notice to pay rent or quit is required. That's why I mentioned, throw out your pre-pandemic 3-day notice you may have been using, because it's just not going to cut it right now. You're going to have to comply with these special requirements that are now required in your 3-day notices, at least from October 21 through March 2022. You're going to have this special language and serve these special notices. Here's some of the special requirements. Any non-payment of rent notice that's given from October through March of 2022 must include the following. And this is pretty obvious. You state the amount of rent that's demanded and the date it's due. So your October 2021 rent is unpaid and due. It was due October 1st. That would satisfy that requirement. And that's pretty standard anyways. Most notices will include that. You must include the telephone number and internet website address of the pertinent government rental assistance program in your area. So that would then also be included in your 3-day notice. You must include the following language in bold text, at least 12-point font. And that is this disclosure right here. Important information about, essentially about the possibility that you can be evicted and that you can seek information or rental assistance through various programs. So again, this language is required as a part of your new 3-day notices. And I say from October through March, at least, who knows? I've seen these laws extended repeatedly throughout the last year and a half. We'll get a law that's passed and is supposed to end at a certain date. It gets kicked out months. This could continue past March. Conceivably now, April 1st, if nothing changes, you could go back to your old 3-day notices, presumably, if nothing else changes. But again, you'd want to consult with a lawyer at that point to see if anything has changed or whether or not it's advisable to use your old 3-day notices. But at least for now, during this period, these are some of the requirements of your new 3-day notices. And guess what? And I have the blowhorn here. and this is applicable across the board, really, you need to apply for rental assistance. The main state website is housingiskey.com. From that website, you can obtain an application. And you have to apply, even if your tenant is not the one who has applied, the landlord, you need to do so. In fact, that is a requirement now to get into the courts, is that you have to have applied for the rental assistance and either obtained it, in which case the eviction is not necessary, or been rejected, or the tenant has not cooperated and a certain time has passed. But the importance now, and I've been preaching this to my clients who call me up and they're looking to evict their tenant or want to get into court to try and collect that past due rent. There's a lot of money available in rental assistance that they're handing out. In fact, I just got off a Zoom chat that I have with landlord attorneys in the Bay Area once a month. And the story came up that, the rental assistance program, they overpaid. They paid twice for a particular tenant. And the landlord, this is another attorney was telling me, their client, that the landlord called up and said, hey, I got this extra money. How do I return it? What do I do? And the rental assistance program said, well, this will apply for, the next few months. So just apply it for the next few months rent. I was floored that was their response, but they've got all this money. Avail yourself of it. Apply. Go to housingiskey.com. Encourage your tenants to cooperate. And, if they don't, then you do have some recourse potentially. But, by and large, I am finding that, there was a period of time in different cities where the money was just not being released. I'm not seeing that as much these days, again, because there's so much money there, and they've now got the process down and they're processing it a lot quicker. In the early stages, it was a little slow going, but I'm hearing success stories where my clients are getting that rental assistance. So first, avail yourself of those programs. Now, this applies, this is one of the mandatory court requirements for unlawful detainers. And the unlawful detainer is the eviction. So if you're going to try and evict for non-payment of rent, one of the requirements is that you avail yourself of any potential assistance, rental assistance, for any time March 1st through March 1st, 2020 through March 2022. So even though the moratorium is expired, my understanding is that they're still giving out money post protected period. So again, from October 2021 through March 2022. So if your tenant does not pay during this time, definitely still apply, and apply each month. So if they don't pay for October, November, apply. If they don't pay for December, apply again. So continue for each month. Again, exhaust those opportunities. I can't really emphasize that enough. So again, housingiskey.com. Okay, so again, this is where I was just talking. So the landlord must first apply for rental assistance and document it. So again, before getting into unlawful detainer world, eviction world, apply, and if you've been denied, then you can get into court on your non-payment of rent eviction lawsuit. So again, this is another obstacle. Even if you are seeking, rent during, pre-October 2021, if you have not applied, you're just not going to be able to get, your unlawful detainer eviction lawsuit through your non-payment of rent. You must first apply and either be denied or apply. 20 days have passed and the tenant's not cooperating. So there's that sort of 20-day cooling window where you give your notice, you try to get into court to evict. Well, if that 20 days has not passed, you're not going to be able to proceed. So again, even though you've got these 3-day notices, I'm really viewing them as at least a 20-day notice, because you've got to let the application process run its course. So really, it's the length of time now is similar to what it was pre-October. So even though you're in the guise of a 3-day notice, you still have that 20-day period minimum to apply, let it run, and then get your case into court. Okay. So for questions about rental assistance, you can check out various websites. You can note these down if you have any questions. Again, the application, which I mentioned a few times, jot this down. And I believe Alexandra will make this available, this presentation available. And I'm happy to make the slides available to her as well if you request that. So jot it down though, housingiskey.com. So there's one exception to this. Let's say you have a brand new tenancy. Tenants started October 1st, 2021. Well, these requirements, these special 3-day notice requirements aren't required for that brand new tenancy. So your tenant started October 1st, 2021. Let's say something happened, hit hard times in December. You don't have to go through all these same procedural requirements, but I would still, in that situation, contact Housing is Key, fill out an application, let them reject you. See if you can't get those funds from some source, all right, before getting into court. Because even, again, getting into court is still going to be somewhat of an obstacle. I'll talk a little bit about that in a minute. But again, avail yourself and know of that one exception, but still try to get the resources or funds from one of these programs that will assist. Well, okay, so we've talked a bit about non-payment of rent eviction lawsuits. What about a rent collection lawsuit? One that is for not for possessions. You're not seeking to displace a tenant, but instead filing your case in court, seeking breach of contract for that unpaid rent. Which, now, just to put into context, remember, you can only evict if the tenant doesn't pay 25% of the rent prior to October 1st, 2021. Well, that 75% that was due doesn't just disappear. You can still hold the tenant responsible for that, just not as part of an eviction lawsuit. So you can file your breach of contract for non-payment of rent case starting November 1st. That was just recently. You can seek that rent in a separate venue, so to speak, still in court, but you're, instead of seeking possession with a non-payment of rent eviction notice, you're simply asking for the rent in a separate action and for a judgment for that rent. Now, you can't take that judgment and evict the tenant for not paying it, but you'll have a piece of paper, assuming you prevail, that would allow you to seek to collect it or hold the tenant responsible. They'd have a judgment on their record. So that rent is still there. It's still due and owing, and you can still seek it, again, if the tenant doesn't pay it and if it's not reimbursed or paid by one of these rental assistance programs. So the earliest date that could have been filed was November 1st. So right now it's fair game. You can file your rent actions in Superior Court. Well, I mentioned Superior Court, and they can also be filed in Small Claims Court, which is typical. The general rules for small claims is that you can file a Small Claims Court action so long as the amount of money due that you're seeking is $10,000 or less. If you're an entity like a corporation or an LLC, you're limited even further, $5,000 or less. Well, guess what? These laws have relaxed those standards and said small claims is open to everyone for any amount, so long as the amount you're seeking is rent that fell due during this COVID period, okay, the COVID pandemic period. So you can file your lawsuit. You're not limited to that $10,000 or $5,000 limit, so long as what you're seeking is rent that was due during that period. Interestingly, rent is not just limited to what the base rent is, the $2,500 a month is stated in the lease, but it could also be other financial obligations that are due under the lease, like utilities. If the tenant owed a certain amount for utilities, potentially you could get into court for those as well in your small claims court or superior court action. So I mentioned these cases can be filed in small claims court or superior court, regardless of the limit. But again, you must first seek that rental assistance and cooperate with the tenant's application for rental assistance as well. You're not going to be able to collect undoubtedly if you do not. So you need to avail yourself of that. And if you do, you can pursue that rental debt in small claims court or superior court. Now, the benefit of small claims court is it's quicker, it's cheaper, it's more informal. But the drawbacks are that you're not entitled to have a lawyer. So you have to and maybe that's not a bad thing, but you have to go it yourself, so to speak. And if a plaintiff loses a small claims court case, it's not appealable. So if you bring your rent debt action and for some reason lose it, you cannot appeal that decision. It's a final decision. Now, if the defendant loses, they can appeal it. So that's one of the limitations of small claims court. But I believe a lot of landlords are availing themselves of the small claims court process because of the efficiency of it. And, it should be a fairly straightforward matter of rent. Again, it's just limited to the rent debt that's due. All right, so what about other evictions? We talked about non-payment of rent evictions, okay? So there are some very strict restrictions on evictions for non-payment of rent and certain hoops you have to jump through. What about, other evictions, violating the rental agreement or, any other basis to evict the tenant? Well, currently, the state does not have any moratorium on other types of evictions, no COVID-related moratorium. So you've sort of fallen back to pre-COVID times as far as the state is concerned. However, state laws may still apply, certain state laws still apply. But one important aspect of this that I have jotted down here is that the state law currently preempts local jurisdictions from passing eviction moratoria. So if your local city or county is seeking to pass some restriction on evictions related to COVID, that is undoubtedly, well, I won't say undoubtedly, it's always arguably, but that is arguably preempted by state law. There are a few exceptions to this that are grandfathered in because of when these local jurisdictions actually passed some moratorium-related restrictions. And those are very few: Oakland, Berkeley, Alameda County, LA, and Fresno. Those are the ones I'm aware of. There may be a few other here and there, but by and large, those local jurisdictions still have strict COVID-related eviction moratoria, generally restricting evictions to only health and safety matters. So if you fall within one of those jurisdictions, consult with an attorney before proceeding with any type of eviction, even non-payment of rent. Those jurisdictions even restrict non-payment of rent. So the first part of this presentation where I was talking about non-payment of rent, you may be restricted in those particular jurisdictions. And there's other jurisdictions that may be ignoring the preemption. These ones that I jotted down here, Oakland, Berkeley, and so forth, those ones are clearly grandfathered in. San Francisco, for instance, is not. However, it has not stopped San Francisco from passing laws purporting to restrict evictions related to COVID. But in my experience, the court has been routinely shutting them down and saying, no, it does not apply because of the state preemption. I know it gets a little bit technical, and this is sort of legalese I'm speaking here, but in general, state law will preempt most local jurisdictions from trying to regulate non-payment of rent evictions and other types of evictions. So you kind of fall back to pre-COVID periods for other types of evictions that you may have. Now, keep in mind, the evictions are still subject to any applicable statewide or local eviction ordinances. So those eviction ordinances that have been in place for years, for instance, Santa Monica, Berkeley, San Francisco, all of them have very strict eviction controls, which if your unit is in those jurisdictions and subject to those laws, you are still subject to the eviction ordinances. And as you may be aware, statewide in January of 2020, a statewide rent and eviction control ordinance was passed for the entire state of California. Those restrictions on evictions do still apply. Those are not related to COVID, but those do still apply if your unit is subject to those laws. Now, rent increases. There is no statewide moratorium limiting rent increases either. So again, the local jurisdiction, I may have this on the next slide. So the local jurisdictions may have some restrictions on that, just like they do for the eviction. So the rent increases are still subject to any statewide or local eviction ordinances. And so if those apply, then you have to still honor those. So refer to your local rent board for any restrictions. So let's say you're in a city or county that does not have any traditional local rent control. Your property may still fall under the statewide rent control ordinance or laws, which, if applicable, limit you to no greater than 5% plus CPI annually. And generally, those statewide ordinance, it applies, the statewide laws apply to virtually all properties, no matter where you're located, throughout the state of California, if you're outside of a local traditional rent control jurisdiction, subject to the exceptions of that law. For instance, single family homes are generally exempt, as are newer constructed properties, properties that have been built within the last 15 years, for instance. But otherwise, most properties will fall under the statewide laws. Or again, if you're in San Francisco, Santa Monica, one of these traditional jurisdictions, you are still subject to those local rent controls and limited to any amounts that the local law will allow. All right. Here's an important thing that's come up, and this is an anti-price gouging law. This is a criminal law that makes it a crime during times of emergency to increase the costs of things. Like the traditional example would be during COVID, immediately after COVID hit, a store owner doubling the price of masks or toilet paper, whatever was in demand, for instance, doubling the price for those. Well, that's exactly what these anti-price gouging measures were implemented to protect. In times of emergency, you can't gouge the public. Well, part of that applies to housing. So during a declaration of emergency, these anti-price gouging laws are in place that say you cannot increase rents greater than 10% for as long as those laws are applicable. So again, this is important because, well, we had a declaration of emergency issued by the governor as it related to the pandemic. Well, that has expired. So that declaration of emergency does not limit these, or does not trigger these anti-price gouging. Well, guess what? The governor passed a drought emergency, as you may recall, in certain counties. I think it was in October, November. Well, that triggered this anti-price gouging law limiting the amount of the increase. Well, that has now expired. Fine. Okay, so now at the state level, you may very well be clear, but guess what? If a local jurisdiction has issued a declaration of emergency, that also implicates or triggers these anti-price gouging laws. So the point is, check to see if there are any declarations of emergency in effect that may limit, if you're outside of a rent jurisdiction and you're intending to raise the rent 25% or greater than 10%, you'll want to just confirm that there's no there's no declaration of emergency in effect in your jurisdiction, in your area at the time of that increase that may implicate the anti-price gouging law. So for instance, in San Francisco just recently, I believe it may have been in December, or actually November, early December, passed its own drought emergency that arguably triggered this anti-price gouging implication. So, locally, San Franciscans are on hold for any increases above 10%. Now, most San Francisco properties are subject to local rent control anyways, which restrict increases greater than 2.5% roughly. So, this doesn't impact a lot of property owners, but those that are exempt from the local jurisdictions, you just have to be aware or cognizant of this potential anti-price gouging implication. So I'm about wrapped up here, and we'll turn it over to Alexandra in a minute for some questions, but just anecdotally, so as this sort of relates back to the end of September, I was fully anticipating the state to extend the non-payment of rent eviction moratorium past September 30th because of how vociferous the tenant bar and tenant advocates were, and how they were saying that a tsunami of non-payment of rent evictions would hit the court, and the pandemic is still in full force, and we just are not prepared and can't brace for this. The same sort of things that they were jumping up and down about for the entire year prior, when the state continued to extend it and ended up extending it to September. I was expecting it to be extended beyond September, and it wasn't. And so I had been telling people as well, look, given all these laws that are in effect, even though the eviction moratorium was expiring, there would not be this tsunami of evictions that are being predicted, that they're way overestimating it and inflating these arguments as a means to try to get more laws to protect the tenants passed. So curiously, I have been tracking evictions locally in the Bay Area, in particular in San Francisco, to sort of track this tsunami of evictions. And I remember I did a talk in I think it was in early November. And according to the housing court in San Francisco, from October 1st until it was early November, this tsunami was exactly 3 non-payment of rent evictions that were filed. 3. Now that's in San Francisco. And I heard, as well as Alameda County, I don't have the numbers there, but they were extremely low there as well. And I would expect probably throughout a lot of the jurisdictions and counties in California, same thing. There just was not this predicted tsunami of evictions that would have warranted further protections. And then I just got off a call, like I was mentioning earlier, with other landlord attorneys, and I got the numbers from November 9th to December 7th, the number of non-payment of rent eviction lawsuits in San Francisco that were filed. So remember, from the prior period, from October, was about 3. There were 29. So again, hardly a tsunami. So certainly the numbers are increasing, and we will expect to see that, I'm sure, as time progresses. But I'm seeing this more as a trickle. Landlords are consulting hopefully with landlord attorneys who are advising them not to rush into court, but instead to follow all these steps. And guess what? Avail yourself of the rental assistance. So I'm assuming that's keeping these numbers down as well. There's a lot of money out there. So, just as a trend, we are not seeing a flood of evictions and really a need for further protections of tenants, for ongoing laws. Although, with these new variants and whatnot, who knows, what sort of effects that may have on the future for further protections that, laws that may be passed. I know locally here, and I saw this as one of the questions that was sent to Alexandra before the talk. Is one of the questions was, when will Alameda County lift its strict eviction ordinance? Strict eviction moratorium. And as I mentioned, there's a few jurisdictions that are grandfathered in that have these very strict COVID-related moratorium. And the answer to that is no clue. I just don't know. There does not. I'm not getting any sense of any budging on that. And their order says we will lift it when we say it's over. So when the emergency is over, we'll tell you when it's over. There's no date set. There's no hard date saying, January 31st, it will lift, and then they extend it. No, it just is indefinite and says it will end when we say it ends. And just as a point also, I mentioned that there's this preemption on local jurisdictions from passing COVID-related restrictions on evictions, the statewide preemption. That ends after March. So in April, the door will be open for local jurisdictions, again, unless things change at the state level, but the door will be open for these local jurisdictions to pass further COVID-related restrictions or further laws limiting evictions depending on the state of things. So, we're not out of the woods yet. And as I've been, as I've been telling Alexander and all of you in these groups, and I'm sure some of you have been on, some of my prior talks, it's just wait and see. I don't know what's going to happen. I can only tell you what things are now and the state of affairs, but it's going to be a wait and see. We'll have to just see how things play out. Just know what you can do now, and don't rush to court with a non-payment of rent case until you have consulted with a lawyer, fine-tuned your 3-day notice, and sought rental assistance through the various programs. So with that, I believe that that wraps it up for what I wanted to talk about. Let me see how we're doing on time. Good. So 45 minutes. We have a good 15 minutes to talk here. I will unshare my screen here once I figured out, Alexander, I'm a little bit of a novice. I should know this now. Here we go. Let's see. That was a new share. Stop share.
I did it for you.
Perfect. Make it easy for me.
Well, thank you so much. That was really interesting. I would like everyone to stay for the Q&A if you can. We have some really great questions. I also have a poll question for you. We are planning our 2022 webinar calendar. So these are some of the topics we have in mind. If you could please vote which topic you would like, or topics, you can select more than one that you'd like to see. In the meantime, I'm going to go through some of these questions here. One of the questions I saw that was interesting was about late fees. Can you include late fees in any sort of small claims lawsuit or eviction lawsuit? Oh, Steve, I think you're muted.
Sorry about that.
No worries.
Trying to do that to drown out any background noise here. So the answer is no. Don't do it. Definitely not an eviction lawsuit. And I seem to recall, a lot of the jurisdictions just simply precluded any late fees during the COVID moratorium period. It's just not a good look anyways. Just don't do it.
Okay. Yeah, I agree. Unfortunately, they're not really as effective as they once were. Okay, so question from Anonymous. If we apply for the rental assistance, but the tenant has moved out and is not responding, what do we do? Do we apply? Do we collect?
Yeah, so guess what? There was a period of time that when a tenant moved out, the rental assistance program, they wouldn't pay. So if the tenant skipped out on rent for a few months and then moved out, the landlord had no recourse through the rental assistance program. However, that has been updated. So if the tenant was in possession and they, owed a few months rent and then tried to skip out, you can still get that rent. But here's the problem: it does require the tenant's cooperation. So the tenant generally has to verify that that rent is due, it's outstanding, he didn't pay it, because the program's not going to, they don't want to double pay for a month or months that have already been paid. So they're going to confirm it with the tenant. And if you're unable to get the cooperation, then you would have to go to either small claims court or superior court to try to collect it.
Okay, great. So that totally, it describes this other one that I got about not being able to apply for rental assistance because of that issue, but I guess that is no longer the case. So they can reapply. Is that your understanding? If the tenant does cooperate and they were rejected, they can reapply again?
Well, that's a good question. If they've been rejected once for that rent, I would certainly encourage that you apply now, reapply for a particular month. It would depend on what that rejection was. If circumstances have changed, then it may be worth applying for that prior rejected month. I'm not sure how the program would treat that, but I would certainly, absolutely, it doesn't hurt to reapply. Just do it, see what happens.
Okay,
Yeah.
good. Jerry, similar line of thought. Can I nag my tenant to apply? How can he prove to me that he applied?
Yeah, so I definitely say, look, this is for everyone's benefit. I don't want to have to go to court to try to collect this from you. I don't want to have to potentially try to evict you to collect it. So this is really for everyone's benefit. Please cooperate, forward them, any information about the program. Try to hold their hand as much as possible. That being said, you can't make them. You just can't. And maybe the threat of going to court, or actually maybe even filing a small claims court action, that will get them to do so. In fact, I heard in San Francisco, they are implementing kiosks. So for those cases, this is for eviction cases that get to court, there will be a kiosk set up to help that tenant apply. So maybe they need that little kick in the butt with a lawsuit filed to get them to cooperate. But again, you just can't make them.
Okay. Well, a similar kind of question as well from Peggy. What if you did apply, you were awarded, but then now they stopped paying rent again? Can you reapply?
Yes, apply for every month. So if the next month they don't pay, apply again.
Okay, so keep trying. Richard asking if you have any comment or experience on commercial rent in arrears in California and how that might differ.
Oh yeah, it definitely. And I'm now there's no state restrictions anymore, and because of that, that has lifted any local jurisdictions from continuing their restrictions on commercial cases. That ended in September, at the end of September. So I'm definitely, absolutely pursuing cases now from October going forward. Now, you need to check your local jurisdiction for whether or not you can get into court for rent that accrued during the COVID period for commercial cases. Because, and I'll give an example, San Francisco, they give a very generous repayment plan for up to 2 years after September 30th for the tenant to pay. So I can't get you into court with a non-payment of rent in a commercial case in San Francisco for rent that accrued before September 30th. But for October 1st, definitely can. So, and for instance, in Oakland, I'm doing non-payment of rent cases. I can potentially get you into court for rent that accrued during the COVID period for commercial, only commercial. So again, it varies by city to city or county to county, but it's clear for October going forward, you're fine to go ahead and proceed at business as usual. Doesn't mean some local jurisdiction might still try to regulate it, but I would argue it's preempted by state law.
Okay. That's good to know. From Stacy asking about the landlord assistance program paying back, do they pay back 100% of the rent or only 25% of the rent due?
Good question. They pay back 100% of the unpaid amount. So if the tenant paid their 25% portion, they'll pay back 75%. They're not going to overpay it, but they should pay back up to 100% of the unpaid amount.
Okay, that's great. So we applied on behalf of the tenants, and we also let them know, what can we do if the tenants do not let us know that they have qualified? Can we evict them? I would assume the landlord would be notified, right? If they qualify or not, if they're
Yeah.
rejected.
If you get a rejection, if they don't qualify, you get a rejection, but usually it's the tenant just not cooperating. Maybe the tenant says, I don't qualify, so I'm not gonna cooperate. I'm not gonna, follow through with the application. Well, then that again opens the door to that, depending on when the rent accrued, to a possible 15-day notice. And then the tenant's obligated to pay at least 25%, and then possibly getting into court on a non-payment of rent eviction, or 100% October through March 2022 with, again, that special 3-day notice. You're just going to have to be able to show that the tenant either didn't cooperate or didn't qualify. So you're still going to have that obstacle. The alternative is you get into small claims court or superior court for that rent.
Okay, a couple people asking for some clarification on when the state ended the COVID declaration of emergency. Two people asked that, just to be clear, the date on when that ended, expired.
September 30th. So that special declaration that was required that you may have been handing out with your 15-day notices, that went away at the end, basically October 1st. So at the end of the day on September 30th.
Okay. And let's see, there was another interesting one I wanted to bring up here, but I think I lost it. Let's see.
Just one point of clarification on that.
Sure.
It went away for rent that was due October 1st going forward. So if you're seeking rent pre-October 1st, that declaration would still apply, but it effectively ended October 1st.
Gotcha. Okay. So someone else asking here about whether or not they can bring the market rent up after a turnover, even if it's over 10% that they have to increase the rent. Is that allowed?
That's a good question. Again, this may go to the anti-price gouging law, and it would depend on why that tenant moved out, whether or not that anti-price gouging applies in your jurisdiction. Traditionally, yes, you can bring it to market. I would just be a little bit hesitant to say categorically yes, but usually if the tenant just moved out on his or own volition, yes, you can do that. If there's some other thing at play here, and if the anti-price gouging law applies in your particular area, you may just want to look into that to see if you're limited to no greater than 10%.
Okay, good advice. Also, what happens if the tenant stops paying rent as of January 1st, 2022, and the landlord didn't file any of those special notices due to the tenant paying rent because the tenant was paying rent on a regular basis? Can the landlord file a 3-day notice for rent, or how is that handled now?
Yeah, so you said January 2022.
2022,
so we're looking, so everything's,
yeah.
so treat that with that special 3-day notice that I talked about. The 3-day notice with all that special language in it, and still applying for rental assistance, letting at least 20 days pass before you get into court to see whether or not they were approved and you get that funding through the rental assistance program. So you're still in that special 3-day notice period that again applies from October 2021 through March 2022.
Okay, and then theoretically after March 2022, it'd be like regular eviction, right? That pre-pandemic style.
Until further notice, yes.
Okay. There is always something. We'll see how it goes. Another person here says, we've always posted incoming rent as oldest owed first. Please advise if they pay current rent, how can we apply that if they owe past rent?
Yeah, don't, so don't apply that. Well, first of all, look at the tenant's rent check.
Mm.
If the tenant in their rent check has said November rent or December rent, there's actually a state law that says you have to apply it toward that period. So I would look toward that, notwithstanding what your prior practices are. And then in terms of just unilaterally applying it to a period that benefits you or the benefits the landlord, I would not do that, but instead avail yourself for the prior rents that were due of the rental assistance that's available through the programs.
Okay, and then also from Anonymous, do you foresee the COVID laws to be changed where the tenant needs to show a need for it? I have some that are working full time, they're not hurt, and they're fully collecting a paycheck.
I don't see anything that will change between now and March that is going to require more than what is already required through the rental assistance program. It's just not going to change. I believe that there may be some box they may have to check that says some sort of need related to it when they're going through the process, but I don't foresee anything greater than that.
Okay, interesting. So Stacy asking, the landlord applied, but the system says that they are already in the system because the tenant applied first. However, the tenant never finished the application. Now it's in limbo, waiting for the tenant to complete it. We contacted the rental assistance program. They said we have to wait for the tenant to complete their end. We can't force them. So then what for rents due from February 2021 to June 2021? And we did deliver all the necessary notices.
Okay, good. So at that point, then it's just reaching out to the tenant, again, doing that hand holding, seeing if you can't get the tenant to cooperate under the threat that this may be subject to the 15-day notice. And maybe you give, again, remember I said sometimes you may need to give that little extra kick to the tenant to get them to cooperate. Maybe that is that 15-day notice with the declaration. But again, during that period, remember, they're only obligated to pay 25% to avoid eviction. So you could potentially threaten, look, we may have to serve a notice, which may end up resulting in an eviction, or we may have to go to court to seek a judgment for this amount, which would be a judgment against you that we could conceivably try to enforce or collect. And maybe that will be enough to get the tenant to step up and cooperate. But again, you just can't force them to.
Okay. Another question here about late fees again. If somebody thinks now we can't do late fees, I think you can charge late fees. It's just difficult to put them into like a lawsuit to get them, right? Is that sort of the idea?
So yeah, for now, you can still have your late fees, but you can never, not even pre-COVID, you can't evict for not paying the late fees as a non-payment of rent. There may be another way around or an angle around it, but you know, it's not one that I typically recommend. So you can, you know, certainly for October and going forward, potentially try to get into court in a non-eviction related manner to try to collect those late fees. But, you know, I've been seeing a trend where, you know, late fee collection actions, even pre-pandemic, good luck. I'm just not seeing it, especially if you have your standard 10%. That's just not going to fly these days. I say that, but, you know, They possibly could. But I'm seeing a trend downward from those percentage late fees more to something that's more rational and reasonable, like $50. Because in order, just a little bit of background, any penalty in a contract in California is void. All right, it's punitive, and it's void as contrary to public policy. You're able to get late fees in under the guise or claim that it's what's known as liquidated damages. So the amount has to bear some reasonable relationship as to what a landlord would actually incur as out-of-pocket costs as a result of a late payment. And it doesn't mean what they'll incur today. It means when at the time they entered into the contract, that amount you've established is a reasonable estimate as to what they would incur. So if you got a $2,500 rent and you're saying 10%, that's a pretty big amount, and that may be tested. If you're saying $50, look, yeah, that's not out of the ordinary as to what someone might bear as a result of a late payment of rent. Again, that's sort of the downward trend I've seen on litigation for late fees, and I just wouldn't push it right now. I just wouldn't.
Yeah,
Wouldn't recommend it.
it's a little tenant friendly at this point, I think, to be asking for late fees as well.
I'd focus on the rent. Just
Yeah,
get the rent
the big stuff.
and get what you can.
Yeah.
If you're able to get the late fees, that's just a bonus. That's extra. Go after the rent. And if you're still inclined to seek the late fees in a small claims court action, knock yourself out. See what you can do. Again, not something that I'm recommending.
Okay. Another great question. Can tenants apply for utility assistance like rental assistance? Per my rental agreement, the tenants are required to pay all the utilities directly to the provider, but a couple of them have hundreds of dollars in past due with sewer charges and other stuff, as I, as the owner, am now required to pay for this if they don't. Is there any assistance for this, or can I evict based on this?
So definitely ask for that as part of your application for rental assistance. It is supposed to be for rent and rent obligations due under the contract. So yes, so absolutely 100% apply for it. And if you're rejected, you can seek that in your either small claims court or superior court action. So that is part of what the court is especially the small claims court. They're opening up to rent that fell due during this period, the pandemic period, and that does include other monetary obligations that are due under the rental agreement. So absolutely seek it.
Okay.
Now, in terms of evicting on it, no, don't include that as part of a non-payment of rent eviction lawsuit. Absolutely not.
It's a separate charge. So, okay, that makes sense. Joshua asked, saying here, we gave a tenant a rent increase notice in July of 2019, so before the pandemic, but the tenant only paid the old rent amount and has refused since to pay the new increased rent. Can we file a small claims court case?
So yeah, first, again, check your local jurisdiction or state. There may have been some limitation on the amount you could have increased it at the time. For instance, like I mentioned, some of these rent control jurisdictions had some limitations on the amounts. State law also has a limitation on the amount. But assuming it was accurate, I would ask for that as part of the rental assistance program. So the tenant only paid X, but this additional amount was due. I would try to collect that before getting into court on that amount. Try to get it through the rental assistance program. If you're unsuccessful, then explore the other options, which may be again, a small claims court or some other type of case. I'd probably be hesitant to a non-payment or rent action. But most likely some sort of a small claims or superior court action if you're not able to get that through the rental assistance program.
Okay, so there are options for that. That's great. Michael here asking, the rental assistance was applied for by both the tenant and the landlord, but the organization handling the case is really slow in paying any amount right now 105 days since approval, still has not paid.
Wow.
Whom should I sue in small claims court? The tenant or the organization? Are they liable in small claims court for handling these funds? What do you think he should do? It's been a long time. The 105 days, it's a third of a year almost.
It sounds like that it sounds to me like the tenant has not been approved in that circumstance. Um, but assuming the tenant has been approved and you're waiting, I would probably, if you're intending to bring some sort of action to try and expedite it, to file your lawsuit against the tenant. It's the tenant's obligation to pay the rent. So if the organization is not paying it, well, then the tenant either hasn't qualified, but that doesn't relieve the tenant of the obligation to pay that amount. Like I said, there in San Francisco, they're intending to set up these kiosks to help facilitate or expedite the process. Maybe that's what they need in this circumstance, is that overt action to give the organization a little kick to try to get that payment out, or reapply. Look, something obviously happened. Most of these organizations have some sort of a contact. I would be in their ear on a regular basis of what's going on. This should have been released, because like I said, early on, I was seeing this quite regularly. There were too many applications, too few people processing the applications, and they were taking months. It sounds to me like this one is just sort of lost in the shuffle, and I would get in someone's ear or reapply, or if push comes to shove, maybe file some sort of an action to see if that helps kick things along.
Okay. Yeah, that is a long time. Lucy here asking a clarification. Is the 25% due each month, or is it 25% for the year? Her tenant paid rent fully for the first half of the year, but then paid nothing and says, well, he already paid 25%.
It's 25% of the rent due for the period March 20th or March 2020 through September 2021. 25% of the rent due by September, and it would apply for, so if the tenant paid for let's say through June, well, July, August, September, October, July, August, and September, those are separate rent obligations. I would take the position that they would owe at least 25% for those 3 months as well. But I'd talk with an attorney before jumping into any sort of non-payment of eviction rent lawsuit. But conceivably, you could serve a 15-day notice now to pay June, July, August, September, whatever it is. And then if the tenant pays 25% pursuant to that notice, then you could not proceed with the eviction in that circumstance. But no, I wouldn't treat prior months' rents that they paid as satisfying their obligation to the 25% of the future rent due. But again, the rental assistance program is out there to hopefully kick in and pay those months and satisfy that obligation.
Okay. Miriam says, I raised my rent 10% with a 60-day notice because the tenants were abusing their water use. Am I within the legal time frame?
Within the legal time frame for
raising
I don't think
rent?
I understand the question.
I think there's two things here. Is she didn't ask this, but I would ask, can you raise the rent 10% first of all, and then if you do raise the rent by any amount, is 60 days the amount of time you have to give them?
Okay, understood. So again, if you're not subject to any limitation locally, then most likely, yes, you can give that 10% or less increase with a 30-day notice or greater. You gave a 60-day notice, that's fine. If it's greater than 10%, you have to give a 90-day notice. So you're probably okay, assuming you are within, compliance with any local limitation.
Okay. So I'm going through some of these questions. It looks like we may have just answered a couple of them. And let's see here. Does a landlord need to apply for rental assistance for every eviction case besides non-payment? Say no.
Oh, I see. Okay. No, I think
Right?
I understand the question. That came up a few times. No, if you've got a separate basis for eviction that has nothing to do with non-payment of rent, then, as I mentioned, in most jurisdictions, any restriction on those types of evictions has been lifted. So no, you can proceed with your again, let's say, they violated, let's say they committed a nuisance and you're evicting them for a nuisance activity. That has nothing to do with non-payment of rent. You don't have any obligation to apply and wait for anything with the rental assistance program. You can proceed with your nuisance eviction. Now, again, remember that's subject to any statewide eviction ordinance like AB 1482, which is that statewide eviction control law that passed in January of 2020, or subject to any local eviction laws like in Santa Monica, San Francisco, your traditional eviction restrictions.
Okay, Antonio is saying here, our lease agreement terminated September 30th, 2021. But the tenant has vacated the property but will not give us back possession. Can we evict? The tenant has vacated the property? Maybe he meant has not vacated the property.
Has not. Okay. So again, so let's say it's after any eviction moratorium period. And so we're talking October 1st. You can generally give your eviction notice so long as you're in compliance with the statewide or any local eviction ordinance. So for instance, if you were subject to AB 1482, which is the statewide eviction law, just because a lease is up does not give you just cause to evict. Now, if you're exempt from that, like for instance, you're a single family home and you're exempt from the statewide eviction moratorium and you're not in any of these traditional cities that have strict eviction controls, then yes, you can give your traditional 30 or 60-day eviction notice. But otherwise, if you are within the statewide eviction laws, then simply the lease expiring is not a just cause for eviction.
Okay. Sandra asking here, this tenant is not going to be approved for rental assistance because he's working full-time. Why should we wait for him to apply when it takes 3 months for them to deny the application? And by then we are 3 months behind.
Well, because the law requires you to do so before you get into eviction land. So before you can file your unlawful detainer action, you're going to have to prove that you've applied and that either the tenant doesn't qualify, you've been rejected, or the tenant has not cooperated. Similarly, if you maybe you don't want to evict, you just simply want to get into court with a rent action. You're just seeking a judgment for the rent that's due. Same thing. You're going to have to show that you have applied or cooperated with the application for rental assistance, or else the court can reduce your judgment or any amount you're entitled to accordingly. So you're just gonna have to go through the motions.
Okay. Maybe you can speak to this. The campfire moratorium for Butte, Colorado? Oh.
No, County, Butte County.
Butte County. I was like, wait a minute. We're still stuck at 10% in totality from November 7th, 2018 through now. Do you know anything about that?
Well, yeah. So again, like I mentioned, certain jurisdictions may have passed emergency declarations related to some disaster. And if that is still in effect, it very well may still implicate the anti-price gouging. And I would not be surprised. I just don't know offhand about Butte County in that particular declaration, emergency declaration, but it wouldn't surprise me. Yeah, it wouldn't. So again, those laws were implicated or passed to protect people from gouging on necessary products and housing. And if it is still in effect, you may be limited to that 10%.
Wow, that's wild. That's a long time. Okay, so that wraps up, I think, all the questions that we had. And I know there were more I sent over to you, Steve. So we will, look at those after as well. I think you covered a lot of the questions people had at the onset, probably all of them. So if you are still watching this, the recording will be provided to you tomorrow. So we will send that out so you can review anything you missed, all of the questions that Steve answered as well. And of course, we'll send you the slides. Steve, thank you for sharing those. That's very helpful. And with that being said, Steve, I really thank you for your time and staying over, the hour mark. We really appreciate it. And I hope to have you back maybe when there's another update coming up, I imagine sometime in the spring. With that March deadline, we might know, maybe something new pops up or an extension. So we'll have you come back and speak to that at that time. So thank you so much. And everyone, happy holidays. We have a webinar next week. It's our last webinar. I'll do a quick plug for it. I'll be doing it. It is going to be on how to read a credit report and avoid a nightmare tenant. I'll send you all the invite in the follow-up email as well, and Steve's info too. So you can connect with Steve if you did have, more detailed questions. So thank you, Steve.
Yeah. Yeah, thank you so much. And I saw we had a little visitor there behind you just a moment ago.
Did she
Um,
pop out?
yeah, so yeah, no, I'm happy to do so. And it sounds like we'll probably need to make a date for sometime as we get closer to the end of March, when some of these things are going to be lifting, and see where we are at that time.
Yes, I'm curious to see it too. Everyone, take the exit survey as you leave. I'd appreciate your thoughts on this presentation and some suggestions for the future ones. Bye, everyone. Have a great
Bye.
week. Take care.